We're talking about restraints of trade. Now, what is a restraint of trade? This is a massive question for a start. It's one of the most complicated and complex areas of employment law. So we can only talk about sort of high level stuff unless you really want some advice about your restraint of trade and your employment contract in relation to what you are going to do next. So let's talk about restraints of trade sort of as a high level. Let's take it just a helicopter view, yeah? So when you're looking down there, it's kind of information, but it's not going to necessarily relate to you directly. So first of all, when we think about restraints of trade, we think about what's in the employment contract. Restraints of trade is sometimes called restrictive covenants, but that's a bit of a complex term, so we're just going to continue calling them restraints of trade. A restraint of trade is when your employer is seeking to restrain you from doing something either now or later. Now that restraint could be about you working for competitors, you going off and taking clients, you taking employees, you dealing with suppliers in a way that means that your employer loses the suppliers. It could be for an amount of time or a geographical region. Now, of course, every employer wants to restrain you for the entire universe for an infinite amount of time. That's what they want, and you want to be restrained zero. Yeah. So there is going to be always some conflict between yourself and the employer about how much a restraint of trade is and what's reasonable. But let's talk about a stock standard restraint of trade. That restraint of trade is going to restrict you from working for competitors and opening your own business and taking clients from your current employer for 12, 6, 3 or 1 month for a geographical area of, if you're in Queensland, Australia, Queensland, Southeast Queensland or Brisbane. Yeah. So first of all, we think about how the restraint is drafted. What is actually written in it? Is it going to be effective in court? What does public policy say about restraints? And really, when we think about public policy, we think that as a public policy, we want employers doing their job. So we want employers out there having a business that's going to be maintained, it's not going to go out of business, so they can employ as many people as they possibly can and make as much money as they possibly can, because that helps the community. And when we think about employees, we think about doing the job that you do best so you earn the most money so you can go out there and spend the most money. Hip hip hooray. But there's conflict there, because for you to earn the most money, it might mean that you need to take, your employer's clients. If you take your employer's clients and they're not going to be able to earn the most money they can make, and therefore there's some conflict there. So your employer's should be seeking to restrain you only as much as it maintains their business efficacy. And you really should be seeking to get out there and find new opportunities. So then we look at, so that's public policy, and then we look at what the courts think about. And the courts think about the construction of the clause. Is it drafted in a way that the courts can give it effect? Look, the answer is actually I have no idea whether your restraint is enforceable in that way, because I would need to read it, I'd need to consider it, I need to think about it. But let's say, as a broad brush stroke, it's going to be enforceable. The next thing we need to think about is what you're thinking about doing or what you've done. So when we think about what you're doing or what you've done, we think about, does that relate to the restraint of trade? Often these things also relate to confidentiality, and I talk about confidentiality on a different part of my website, so take a look at that. But often confidentiality and restraints of trade go hand in hand. But let's say, for an example, you are a salesperson. You go out and you decide that you want to leave your job. You've been working in this job as sales for about 5 years now. You've got some pretty good relationships. You know that if you let those clients know that you've moved on to a different company that's a direct competitor, then there's a good chance that you might get them to move across. You've got to be really careful with that sort of conduct. Obviously, just putting on LinkedIn that you've moved from A to B is not inducing that client to come over to you. But if you send them a message and say, hey, I've come from A to B, would you like to see what sort of things we can provide you? Then there might be some inducement there. So it's all about your conduct. It's all about what you're doing. It's all about what you've done. It's also about what you're thinking about doing and how you've gone about doing it. So you might be a salesman who's gone to a competitor, but you have no intention of taking any clients, but you've had a couple of people call you. Hey, look, I've heard you've gone over to A, B, and C. I really want to leave X, Y, and Z. I really don't think they've been helping me out, and my contract with them is coming to an end in about 4 months. Can I talk to you about what that might look like? Now that's a really difficult thing because you haven't induced them, but indeed you know what was going on with employer X, Y, and Z. You know the sort of treatment that X, Y, and Z was giving this client. You know what the fees were. You know how the structure was, and you probably have access to the contract itself because you may have sold that deal to that client. So you've got to be really careful about how you use that information to bring these people across. So just be aware that that's where confidentiality falls into it as well, and your knowledge of the business and its workings. So now we've got a situation where you've been a salesman, you've left, you're working for a direct competitor, and you've got clients that are calling you up. And your ex-employer sent you a rather strong letter saying, we know that you've gone to employer A, B, and C. We know that clients are coming to you. We know that you're talking to those clients. We want you to stop. It is in breach of your employment contract. Now, this is where things get a bit tricky. Some people say, restraints of trade are not worth the paper they're written on. Actually, that's not true. I can assure you that we can draft, certainly MJT Law can draft restraints of trade that will be enforceable. That's not to say your employment contract has an enforceable clause in it, or what you're doing means that the clause is enforceable, even if it was an enforceable clause. But I can assure you that there are ways to draft restraints of trades to make them enforceable. So please don't start with the proviso of it's never going to get up, because it might. Also, your conduct may have pushed you past a position where it wouldn't have been enforceable, and now it is. So think very carefully before you start ignoring those letters. Certainly seek legal assistance. We can help you there. Give us a call. We can talk about what sort of letter you received. We can look at your employment contract. We can look at what you've been doing. We can look at what you've done. We can look at what your new employer is looking at, and we can give you some advice about what your exposure is. The other thing we can do is we can help you either amend those restraints of trade before you sign an employment contract, or have those restraints of trade taken out altogether. Now, one of the things that we get asked a lot is, hey, look, I've been working for my employer for forever, for 5 years, for 10 years, for 1 year, who knows? But now they've given me an employment contract they want me to sign. Has a restraint of trade in it? Do I have to sign it? Look, the simple fact is, if you're working for somebody and you already have a written agreement in place, or you're working for somebody and you don't have a written agreement in place, you are still under an employment relationship agreement. Yep. So you don't have to change that agreement if you don't want to. And it is not okay for your employer to treat you adversely because you're exercising that workplace right. And that falls into the environment of general protections. So stop and think about whether you might have a general protections application if your employer is adversely treating you for trying to exercise that workplace right in relation to the contract. If you have been presented with an employment contract that has some terms in it that you don't agree with, but there's probably some terms that you do agree with, then we recommend you enter into negotiations with your employer to look at amending or removing the terms that you don't agree with. And that will include possibly the restraint of trade. So we can talk to your employer about perhaps watering down the restraint of trade or removing it altogether. That's a matter for you, and it's a matter for you and your employer. But ultimately, if you're presented with a new employment contract or one for the first time, and it includes a restraint of trade, you can actually refuse to sign it, and that's your lawful right. Now just remember, if you are dealing with restraints of trade and you have and you've got a written contract, that's all well and good. You will be able to figure out here at MJT Law what the situation is by reading the contract, speaking to you, finding out what's happening. But just remember that there are certain conditions that are implied into all employment contracts, whether you have a written agreement or not. And a lot of those are in and around confidentiality. So before you decide you're going to work for a competitor, take some of the information with you and benefit from that information. Even if you don't have a restraint of trade, just remember that there may well be some implied confidentiality issues there, or there's implied confidentiality restrictions that you'll need to think about. And we can certainly assist you and help you work out what that means to you and how you're going to work with that, and whether indeed we need to have an agreement with your previous employer about what you're doing next, and we can help you have those discussions. And if for some reason your employer decides that they're going to sue you for a breach of restraint of trade or a breach of confidentiality or goodwill or something along those lines, and they're taking you to court, contact us. We can absolutely help you through that litigation matter. We can help you from go to woe. So we can perhaps have a negotiation with your employer to stop the litigation in its tracks, or we can defend you in the court process and hopefully get a really good result for you. Of course, we are not the decision maker, so we cannot guarantee a decision, but we can certainly help you get the best result possible. Thank you for watching.